Hi, everyone. Thank you so much for being here today. As Ali said, I'm Rebecca DiNucci. I'm one of the attorneys with Anderson Elder Law. Today's presentation is about estate planning, not just for the wealthy, not just for retirees, but for everyone at every stage of life. Whether you're just entering adulthood or enjoying your retirement years, a solid plan gives you peace of mind, protects your loved ones, and ensures that your wishes are honored. Estate planning really isn't just about death and taxes, it's about preparation, clarity, and support. So let's just jump right in. As Ali said, we take a holistic approach to our planning. Our services go beyond just drafting wills. We assist families with long term care planning, special needs trusts, guardianships, and veterans benefits. We also help guide clients through the maze of Medicaid and estate administration during um, usually what's the most difficult time of a client's life. When you work with us, you're not just getting a set of documents, you're really getting a whole team that supports your personal, financial, and legal needs. Oftentimes, we get asked the question, what do elder law attorneys do? An elder law attorney is different than a general estate planner. We also cover the basics. We do wills, trusts, powers of attorney, and healthcare directives. But we also handle more specialized areas such as planning for long term care and public benefits, financing long term care, getting on Medicaid is a very specific area which isn't covered by general estate planning. We also support families through crisis situations like nursing home placements, helping clients find the right fit, both personally and financially. We also create plans for children or adults with special needs. And we serve as advocates and planners working in connection with financial advisors, care managers, and healthcare providers. Now to go into the estate planning basics. There are general documents that everyone, regardless of age, needs to have. The documents will protect you while you're alive and also provide guidance after you're gone. We'll go through each one of these documents and I'll give you a little bit more detail. So, really, one of the most important documents is a general durable power of attorney. Everybody always thinks about a will and usually forgets how important a general durable power of attorney is. This document authorizes someone you trust, usually a spouse, family member, or close friend, to manage your financial affairs. It can be effective either upon incapacity or it can be effective immediately upon signing. It's really important to have because when you think about your day-to-day life, if you're unable to handle paying bills, handle your banking, filing your taxes, managing your real estate, there's a lot of work to do. And if you're no longer able to do it and you do not have this document and you have not named someone who's able to serve as your agent, the only option for your family is to go to court and petition for a guardianship. That's time consuming, expensive, and invasive. Having a durable power of attorney that sets up the chain of command can avoid that situation. The next document is a healthcare power of attorney. This is where you name someone to make medical decisions for you only if you're unable to make your medical decisions yourself. So it's really important that you've had a discussion with this person. You want someone who understands your values, who can talk to doctors confidently, and who won't hesitate under pressure. Sometimes when we meet with clients want to name all three kids, and the reason is just so it seems fair. Really, it's more important to choose the people who will do the best job at whatever particular document you're naming them in, whether it's the financial power of attorney or healthcare power of attorney. It's more important to choose for the financial power of attorney someone who can handle the finances, who will be able to take on that burden. And then for healthcare, someone who can make those tough decisions or is able to follow the wishes that you've laid out. We always recommend having a conversation with your healthcare agent when you do your document. Have the conversation about what types of care you would want, what you would not want. Um, People really, everybody agrees that this is an important conversation to have, but most people just put it off and don't actually do it. The easiest and best time to talk about this with your loved ones is when you're healthy and you're not in a crisis. So I recommend having that conversation, even though it's uncomfortable and can be, unpleasant. Then we do a combined document where we have a healthcare power of attorney combined with a living will. Sometimes those are separate documents. It really doesn't matter as long as it has all the different pieces. In terms of a living will or an advance directive, this is where it outlines your preferences for life-sustaining treatment in a serious or end-of-life situation. There's questions in that document like, would you want to be on a ventilator? What about a feeding tube? Would you prefer comfort care only? And this part of the document is for seriously ill when you are end stage medical condition, which is determined under Act 69 by a medical professional who would say you are end stage, and then you have laid out your wishes. So this part of the document only applies if you are end stage medical. This document then, by making these choices, this document removes the burden of the decision making from your loved ones and provides clear direction to your healthcare team. It's a benefit for you to know your wishes will be followed, and it's also a huge burden lifted from your family to try and guess what you would have wanted, or it deals with prevents any conflict between family members as to what you would want. Those are the documents that you really need during life. And then now we'll shift gears into the important documents that deal with your assets once you pass away. The first of those is a will. Your will specifies how your assets are distributed at your death. And if you have minor children, this is the place where you can name their guardian. Without a will, the Pennsylvania laws of intestacy determines how your probate assets will pass. So usually that's not a great option for most people. The Pennsylvania laws of intestacy have different scenarios that are laid out that will determine, based on whether you're married or you have children or your parents are alive, how the assets will pass. Sometimes it's exactly what someone would want, but more often than not, it doesn't fit the situation perfectly. So it's much better to have a will and make sure that everything is buttoned up and taken care of, and we know exactly who's going to inherit. Also, without a will, if there's two parents and one passes away, obviously the surviving parent is the guardian. But if both parents pass away and you have minor children, if you do not have a document that specifies the guardian, then the court is the one who steps in to decide. It's obviously costly, there's a delay, and it also might not be the person you would have chosen. So it's really important to make sure that you deal with that as soon as you have children. I recently spoke with someone who kept saying, I just want it to be simple. I don't want to spend a lot of time thinking about my will. And he kept saying, I want it to be simple. I want it to be simple. And finally, I think I got through to him that the way to make it simple for your family is to have a complete set of documents, to have a will, to have everything laid out. And then that is what will simplify it for your family and loved ones once you have passed away. Now, another option that works in conjunction with a will is a trust. And there are multiple different kinds of trusts, but a trust can be a tool that is used to go beyond what a will can do. It can control how and when your assets are distributed. It can help avoid probate. It can provide for loved ones in complex situations, such as minors who are inheriting someone with a disability or blended families. It also, in some situations, depending on the type of trust, can protect assets from creditors or long-term care costs. That's when we use an irrevocable trust. There are many different kinds of trusts. There's a revocable trust, there's irrevocable trust, special needs trust. Each trust serves a different purpose. It can be especially helpful if you have out-of-state real estate. We see that frequently in dealing with people don't want to have to deal with probate in another state. So to avoid ancillary probate, we might put a piece of real estate in a living trust. So why do these documents matter? Having all of these documents, which can seem like a lot, especially when someone comes in and they say, I just want a will. And then we go through, well, why you really need all of the documents in order to have a complete plan. They give your loved ones the legal authority to act on your behalf without court involvement. They spare your family the stress of guessing as to what you would have wanted. And most importantly, they ensure your voice is heard when you're no longer around or you're unable to speak for yourself. Modern estate planning also includes beneficiary designations. Most people have a significant portion of their wealth in retirement accounts or assets that pass outside of their will. So part of our work is to make sure the beneficiary designations make sense with your estate plan, make sure they're up to date. So we, make sure that when we're doing your estate plan, that all of the beneficiary designations are updated as well. Those need to be reviewed regularly to make sure that everything still works in conjunction for a complete estate plan. We also look at financial accounts and the organization. It's important to know, for us to know how assets are titled, how accounts are titled, and how they will transfer. We do that to prevent confusion in the future. Probate in Pennsylvania isn't particularly difficult, but it's burdensome. There are expenses with it. So we like to make sure that assets are titled correctly to avoid probate if necessary. Recently, I had a married couple, and the financial advisor set up an account, and it wasn't titled correctly. So at the death of one spouse, the other spouse had to go through probate, but they had thought the account was set up with rights of survivorship, but it wasn't. So, again, it's not the end of the world. We did go through probate and get it straightened out, but that's why we ensure as part of our work that the accounts are titled correctly. Another thing to think about when doing your estate planning is your digital assets. What happens to your email, social media, or online business accounts when you die? Planning for digital assets is just growing more and more important as people have more things online and a lot of passwords and that are constantly changing. So that's another thing that just makes it easier on your beneficiaries if you have that organized so they can get the information easily once you pass away. I'm going to shift gears a little bit into different types of trusts. There's two primary trusts. One is a revocable trust where you keep full control over your assets. It can allow for centralized management, but the grantor can retain control over the assets. There's no creditor protection, but again, it can allow for you to avoid probate in another state. It can provide for centralized management. So there's other reasons to have a revocable trust aside from, creditor protection, because that is not a benefit of a revocable trust. Now, an irrevocable trust is completely different. And this is what people, I think, have heard a lot about. Oftentimes people come in and say, I heard from so-and-so or my neighbor or friend that I should put my house in a trust. I don't want the nursing home to get it. And this comes up all the time. And it does work in some situations. It's not for everyone. When you put assets in an irrevocable trust, the grantor no longer has control over those assets. So you are essentially making a gift to the trust. Now, that's not for everyone, because sometimes the thought of actually putting your house in a trust and losing complete control and not being able to sell it if you need the funds for your care needs, it doesn't work for a lot of people. And the other thing to think about with putting assets in an irrevocable trust is it's still subject to the 5-year look back for Medicaid. When you apply for Medicaid, Medicaid looks back 5 years, and anything that goes into the trust, you have to wait. If it's been longer than 5 years, then it's protected. But if it's in the past 5 years, then that's also considered. So it works really well, especially when people do a lot of advanced planning. So if you're thinking about this years in advance and you have a beach house or something, that's a typical asset that goes in an irrevocable trust. That can be a great option, but it requires you to do your planning in advance because of the 5-year look back. All right. The next slide talks about probate versus non-probate assets. And when we do the financial organization that I talked about, we go through what assets are your probate assets and what assets are your non-probate assets. Probate assets are the assets that will go through the court-supervised process of probate. That's what probate is. It includes individually owned property, such as bank accounts that don't have beneficiaries or bank accounts that aren't jointly owned. It can be time-consuming and costly, but sometimes it's necessary. And I always say we don't want to let the tail wag the dog. We don't want to simply try and avoid probate just to avoid probate. Sometimes when people get it in their heads that they absolutely want to avoid probate, they start doing things like adding their kids' names to their bank accounts and adding their kids' names to their real estate, which can cause issues much bigger than going through probate. So that's why it's important to talk to a professional and go through the complete list of assets to see what would actually happen and what the goals are for those assets. Non-probate assets are assets that will transfer directly to your beneficiaries. It includes jointly owned property, accounts with beneficiaries, which we've already talked about, or assets in a trust. This is a faster distribution because it's not going through probate, not going through the court process. However, this doesn't eliminate Pennsylvania inheritance tax. So Pennsylvania inheritance tax will be on all assets. The first dollar is taxed other than life insurance. So adding a beneficiary on a bank account or adding a joint owner on a bank account does not eliminate Pennsylvania inheritance tax, and the Pennsylvania inheritance tax return will still need to be filed as well. Okay, I'm going to pause. Ali, do we have any questions at this point, or are we good to keep moving on?
Good to keep moving on.
All right, perfect. So the next slide is now we're getting into the estate planning that's really necessary at different ages. So we have recently started at our law firm a young adult planning package. And it's a great option because when people turn 18, honestly, the last thing they're usually thinking of is getting their documents in order. But as soon as your child turns 18, they're legally an adult. This means that parents can't access their medical or financial information, even in an emergency, unless you have the right legal documents. So we have started doing this, and we've had a great response of young adults who are going off to college, and parents want to make sure that they have their documents, that their children have their documents in order prior to leaving. So for college age adults, 18 and older, we really recommend that you have a healthcare power of attorney, as well as a HIPAA release. This allows your parents or whoever's named in the documents to speak to the doctors, make medical decisions if the adult child is not able to do so. A durable power of attorney, so the parent can help with finances, help with banking, help with taxes, basically anything that they might need assistance with. We also provide a FERPA form, which allows the parent to access college records. Sometimes when the college age child sets up their online portal with the college, they automatically, when you're clicking through, require you to do a FERPA form. Some don't. And so parents legally cannot access any of the college information, college records. So that's another document we recommend for adults that age. And then a living will. This, whenever I go over this with these young adults, they really haven't given much thought to it. I understand they're 18, 19, 20 years old, but it's still worthwhile for them to think about if they had no brain activity, if they were in an end stage medical condition, what choices they would want, what medical care would be appropriate. So they usually haven't given it any thought prior to going over it, but it's still a good document for them to have. And so their parents or loved ones know their wishes. So it's not really necessary for a adult, a young adult this age to have a will, but the other documents are really critical once they turn 18. Then when they get a little bit older to their 20s and 30s, estate planning really matters here as well. Usually people don't really think much about it. They're just starting their careers, they're accumulating assets, and maybe getting married or having kids. At this point, it's really about building a foundation. You need to prepare for the unexpected. You need to think about establishing a chain of command in terms of the financial power of attorney and the healthcare power of attorney. Create at least a basic will, name beneficiaries on the accounts, and think about the digital assets. Usually what happens is people come in once they have children, they are concerned who will raise the kids. We need to name a guardian. And that is usually what gets people to start actually thinking about this. It's important to name a legal guardian. Also think about, if you have minor children, how will your assets go to your minor children? We can set up a trust. Who will be the trustee? Who will manage these assets? So there's a lot of things to think about when you have minor children. Also, people, when they're having young children, are busy enough, but people oftentimes at that age also are stepping into the role of caregiver for their aging parents or in-laws. So, their parents are going a little bit downhill, and maybe their kids have started to help them with their finances. And so they will also see, what's needed in order to help their parents. And sometimes that will trigger them to get their own documents in order. So it's important for them to take care of their own documents, and then also that their parents have all the documents so that they can step in and help them. This is an ideal age to start having broader family conversations where the younger adult talks to their parents about what care they would want in the end stage of life, and vice versa. So again, I can't stress this enough. The conversations are uncomfortable, but they are essential. They allow families to plan collaboratively. It reduces confusion and conflict down the road. So that's just another reminder to just make sure to have the conversations with your families now. So then we get to midlife planning, and that's by your 40s to your 60s. The planning usually gets more complex, not always, but people usually often have a home, often have retirement savings. They're dealing with college expenses for children, and again, the responsibility for aging parents. What I usually see is people do their documents when their kids are born, they have babies or young children, they do their documents, and then they come back 30 years later, when they took a look at their wills and they realized, oh, none of this applies anymore, because it's all about who's going to be the guardian for my children, who's going to be the trustee of their trust. And now they need to shift gears and change everything now that their children are grown. So we see that all the time, where they took care of it once and then realize again, once their children are grown, it's time to do an update. Even if if you've never taken care of it, there's no time like the present to do your documents. It's never too late. Another reminder, if you don't have any documents, if you haven't established a chain of command, there's no one to act in an emergency, and you really want to avoid the pain and the stress of your family having to get a guardianship over you. So that is just something to just keep in mind, that if you don't take care of it and the bad thing happens, there's really no alternative if you're not able to do documents at that point to a guardianship. And then in your retirement years, your 60s and beyond, oftentimes people are focused on legacy planning, thinking about their adult children receiving assets, or even their grandchildren, education planning. People start to think about looking at their assets and thinking about long-term care planning. Where will they age? How do they want to finance that option? And we look at that and sometimes help people with a 5-year plan, or a plan to think about what might be necessary in terms of healthcare down the road. So that's part of what we do as well. It's not just, like I said, the estate planning. It's also, thinking about the long-term care planning as well. At this age, we really say every 5 years you should review your documents and make sure that everything still makes sense. You want to make sure that if there's any major life change, a death, a divorce, anything like that, you want to take your documents out, make sure that everything still makes sense when you did the documents in the first place. Sometimes people do documents and then 5 years later, everything is still perfect and it still works, and that's great. You don't need to make any changes, but you just want to check on it every 5 years, or if there is a major life change. Some of the biggest planning mistakes that we see is having an outdated set of documents after a divorce or the birth of a child. Or not planning for incapacity. People come in and they did their wills. That's the only thing they did, but they don't actually have any plans for what's going to happen now, like during their lifetime, if they become incapacitated, who's going to be the chain of command. Another failure that's not on here, but that we see, is people who try and do a very simple plan for a complex estate. And, that doesn't work well. It's better to speak with a professional, make sure that the estate plan fits your particular situation, such as in a blended family or a family with children or adult children with special needs. We sometimes see parents who say, well, I'm just going to not plan for my adult child with special needs and count on the other children to do the right thing and take care of that third or fourth child. That's not a plan. It's really important to just make sure that your documents are in place to fit your family situation. Another thing is we advise that you talk to your fiduciaries, have the conversation that you've named them in your documents, get their okay to do that. And make sure they understand and are okay with their role in your plan. So again, people don't usually like to have this conversation, but it's better that they are aware that they're named and have an idea where the documents are located. If you don't give them a copy of the documents, which is fine, you say, listen, I've done these documents, this is where I keep them. So that way, if something happens to you, your family or friends know where to actually get the documents. And then the other problem that we see relatively frequently is not naming backups in your document. This all goes back again to establishing a chain of command. You want to make sure that you don't just have one person listed, that you have a backup and maybe even a third option in case the first person is unable or unwilling to serve. All of this planning really avoids confusion, conflict, and court involvement. So the more you plan now, the better it will be in the future for your family and your beneficiaries. I think I've already pretty much touched on this, that you want to regularly review and update your plan, work together with your financial advisor and your lawyer. And again, keep the important documents somewhere where your agent or family knows where to find them and have the conversation with your beneficiaries. Your estate plan isn't one and done. So you can't do it once and then not think about it again ever. Like I said, you want to check on it, make sure that it's still a reflection of your wishes. If not, then you would need to modify it to reflect the changes in your life. So that's really everything. It's a brief overview of all of the documents people need at different ages. I hope this gave you a clear sense of how estate planning fits in at each different age. We here are passionate about making sure that people have a plan, that it's organized and can be implemented. So if you don't have any questions, if you do have questions, you can jump in now. If not, thank you so much for joining us today.
Becky, we have one question. With respect to retirement planning, what are your thoughts about a qualified personal residence trust?
So it really depends. That's not helpful, I know. But again, it's in terms of a trust for your residence, it is so specific, and that's where it really depends on what your long-term plans are, what your other assets are. For example, I spoke to someone recently who was going to put their residence in a trust, and then when we really, got down to it, she said, well, but if I needed to go into a personal care facility, I would actually sell my residence and use that money for my care. So her primary goal actually wasn't preserving the residence for family members. It was using the assets. So that is just one thing that I think is so specific to a person, to a family. And the comment says it's for a vacation home, not a primary residence. Yeah, that's the same thing. That is what I talked a little bit about before. It can be a great option. We see it a lot for beach homes specifically, where they have increased so much in value that they are the perfect asset to go into an irrevocable trust. And we do that very frequently. Again, this depends on all of the other assets, because if you are going to need long-term care planning in the future, there is still the 5-year look back with Medicaid. But yes, an irrevocable trust is a great option, especially for second home properties.
Okay.
I see another. I recently moved to Pennsylvania. I have all your suggested documents, but drawn in Delaware. Do I need to do anything? So if you have documents that are valid in another state where they were created, they are valid in all 50 states. So you do not technically need to do anything immediately. Your documents would be good here. However, it's worth it to have a lawyer in Pennsylvania just take a look at them. Sometimes it is worthwhile to update them because the healthcare power of attorney might be different than what medical doctors are used to seeing, because our healthcare power of attorney is based on Act 169, which is a Pennsylvania law. So it's just worth it to take a look. You may or may not need to update it, but if something happened before you got a chance to do that, your documents are still valid in Pennsylvania. Any
Okay.
other questions? Oh, so our fee structure for estate planning, again, I'm sorry to say it depends. When we have a consultation, it's a working appointment where you provide you provide a lot of information for us. So in our consultation, we are going in, we can have a working appointment about what your assets are, what the estate planning would be, and then we let you know the fee at that time. It's just really dependent on your family situation. Anything else?
Great. Thank you, Becky.
All right. Thank you so much.